and assume in the absence of Council of Ministers that there is a Council of Ministers. And then you pass a presidential order that even in the absence of Council of Ministers, the governor is acting on the aid and advice of the Council of Ministers. What kind of exercise of executive power there is this? This is a mockery. Which is why I've been saying it's only a political act. It's not a constitutional act. The governor of the state of Jammu and Kashmir gave a press statement on the night of 3rd of August that he was not aware of any proposal to amend 370 or Article 35A, and that all security arrangements and reinforcements of the state were being made pursuant to intelligence inputs forecasting a major terror incident. On the 5th of August at 11 a.m., on August 5, the President issued the impugned order titled the Constitution Application to Jammu and Kashmir Order 2019. This is CO 272. Well, let's therefore mark it's an executive act. The said order issued under Article 371 with the purported concurrence of the government of the state of Jammu and Kashmir inserted Article 367(4) of the Constitution of India. So that's what CO 20272 did. In particular, the newly inserted Article 367(4)(c) stated that references in the Constitution to the government of the state of Jammu and Kashmir would be construed as including references to the governor of Jammu and Kashmir. Further, 367(4)(d) amended subclause 3 of Article 370 by replacing the expression Constituent Assembly of the State with the Legislative Assembly of the State. Executive Act. Now, let's come and look at that. It's in volume 3, PDF page 101. That's right.
Volume 3 of what?
3
Documents.
of documents.
Document.
Yes.
Page 101.
101. Running page 494. Okay. Now, kindly note, Malat, at this point in time, 356 was in operation.
Volume, Mr. Sibul? Volume?
Volume 3, documents, volume 3, PDF page
compilation. Documents
101. Note, Malat, at this time, 356 was in operation.
This is 5th August 2019 notification.
That's right. In exercise of the powers conferred by Clause 1 of 370 of the Constitution, the President, with the concurrence of the government of the state of Jammu and Kashmir, could never be done. Because other than 92, 36, and 38, Governor could only act on the aid and advice of the Council of Ministers. That's the Jammu Kashmir Constitution. The governor could not represent the state. So the very inception of this executive order is constitutionally flawed. In exercise of the powers conferred by Clause 1 of 370, the President, with the concurrence of the government of the state of Jammu and Kashmir, is placed to make the following order. This order may be called the Constitution Application to Jammu and Kashmir Order of 2019. It shall come into force at once and shall thereupon supersede the Constitution Application to Jammu and Kashmir Order 1954, because all amendments thereafter were to the 54 order, as amended from time to time. All the provisions of the Constitution as amended from time to time shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows. So, to Article 367 shall be added the following clause. 4. For the purposes of this Constitution as it applies in relation to the state of Jammu and Kashmir, reference to this Constitution or to the provisions thereof shall be construed as reference to the Constitution or the provisions thereof as applicable or as applied in relation to the state. reference to the person for the time being recognized by the President on the recommendation of the Legislative Assembly of the state as Sadr Riyasat of Jammu and Kashmir, acting on the advice of Council of Ministers of the state for the time being in office, shall be construed as references to the Governor of Jammu and Kashmir. And references to the government of the state shall be construed as including references to the Governor of Jammu and Kashmir, acting on the advice of the Council of Ministers. How can that be? There is no Council of Ministers. So you create a constitutional myth and assume in the absence of Council of Ministers that there is a Council of Ministers. And then you pass a presidential order that even in the absence of Council of Ministers, the governor is acting on the aid and advice of the Council of Ministers. What kind of exercise of executive power there is this? This is a mockery. Which is why I've been saying it's only a political act. It's not a constitutional act. You wanted to do something, you did it. D is even more serious. I don't think in any constitutional democracy in the world this has happened. In the famous Miller case in the UK, Maharaj, Boris Johnson tried to bypass Parliament and requested the Queen to prorogue the House. The House was prorogued. Immediately, Maharaj, matter came to the Supreme Court. All the justices of the court said, "No, Maharaj, your Lordship knows this is the executive power of the government. They can prorogue the House." But all came to a unanimous decision. You cannot even prorogue the House like this. You cannot exercise executive power to bypass Parliament. You bypass discussion in Parliament. That's not the way constitutional democracies work. And this is much worse. You assume something that doesn't exist. You give powers to the governor which he does not have. You assume to yourself under 350 all the powers of the state legislature. You are Parliament, so you therefore invoke the powers of the state legislature and Parliament, and you pass an executive order. What kind of exercise of law is that, or constitutional law? And then D, in the proviso to clause 3 of Article 370 of this Constitution, the expression Constituent Assembly of the state referred to in clause 2 shall be the Legislative Assembly of the state. What power does the President have to pass such an order? We're not dealing here with exercise of constitutional power. We're dealing with exercise of executive power.